Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division First Department, or arguments for this afternoon, February 21, 2024. So you guys all know the spiel. Only ask for the time that you actually need to bring out the salient points in your briefs. I can assure you we have read your briefs and we are fully familiar with your arguments. First case, People v. Darnell Coleman. I'm sorry, you said 1 minute? 4 minutes. Yes. 414, matter of 8 children. That matter is submitted. Asian versus Flintlock Construction.
Respondent, was 5 minutes?
525. Who do you represent? 525 and 4. EVUNP Holdings versus Friedman. Thank you. The matter is submitted. Lehman Brothers versus AG Financial.
For the appellant, Your Honor, we request 9 minutes and 2 for a vote.
Dr. Cooper, for the respondent, request 9 minutes.
727, Hayes versus Anderson and Shepard.
For the appellant, 6 and 2.
The respondent, 4.
5 and 2 and 4. People versus Arthur Haynes. That matter is submitted. Dye versus RBNB 20 owner. That matter is submitted. Ma v. Chen. That matter is submitted. First case on for argument, People v. Darnell Coleman.
Step up.
You may proceed.
Good afternoon, Your Honors. My name is Desiree Sheridan for Appellant Darnell Coleman. In this case, I wanted to address the warrant issue. In this particular instance, the warrant was not supported by probable cause based on the affidavit submitted by Detective Reich in this case.
So you received the redacted affidavit, is that correct?
Correct.
And the unredacted affidavit with the actual search warrant was presented to the court, is that correct?
Correct.
And the court made a determination based upon its reading of the unredacted affidavit that there was sufficient basis to issue the warrant.
Correct.
So why should we not? Why should that not stand?
In this instance, the affidavit that was submitted failed to indicate what basis there was for the detective's determination that the amount of time between when appellant left his apartment and met with the informant, what that amount of time actually was. He used these conclusory terms like a short time later, a short while later, a while later, and specifically CPL 690-35-3C says that the affidavit has to contain allegations of fact.
So if we reviewed the unredacted affidavit and search warrant and found and agreed with the trial court, that would be fine. Is that correct?
Okay.
That would be okay.
Yeah, correct.
Okay.
But nevertheless, despite what happened between the court and Detective Reich, which I don't think they examined him, or the court and the informant, the fact is that the affidavit, as it appeared, still didn't specify the basis for concluding that the amount of time that surpassed was either a short while or a while later.
But what is controlling is what was presented to the judge. Is that correct? In terms of the information that was presented to the judge, and also any questions that the judge had of the individuals?
Correct, except that in this case, I don't believe, because reading Judge Klotz's opinion, he also used that same sort of non-specific conclusory term of saying that immediately after the phone call. And the issue is that there's no information or no facts from which to conclude or ascertain that, in fact, this was a short time. It could have been 15 minutes, it could have been 5 minutes, because that's such a subjective determination. In the affidavit, the officer should have specified 5 minutes, or, appellant left his apartment at 9:10, he arrived at the location at 9:20. So then you can conclude 10 minutes, okay,
Counsel-
perhaps that is.
Is it possible that the omission of specific information such as that is designed to protect the CI, the confidential informant?
Well, I mean, I don't think that in this circumstance that would really, because the appellant met with the person who he sold
Well, you just said that the time, the actual hour at which the observation took place should have been indicated. Wouldn't that allow the defendant to peg who it was that was supplying the information?
I don't really think that would be the case, because the defendant's going to know where the transactions allegedly occurred, so he would know who he saw when he went to that location.
Unless
So
the
I don't,
defendant regularly conducted business in the vehicle, and there were many people who purchased drugs in the vehicle.
except that in this situation, they were not purchased in the vehicle, they were purchased in an outside location.
Thank you. You have time on rebuttal.
Your Honors, and may it please the Court, Anna Nachik for the people.
I want to be clear, as a preliminary matter, are you contesting the fact that the waiver of appeal is invalid?
Your Honor, it is our position that the waiver of appeal is valid, but that the claim that the search warrant was invalid is meritless in any event, even if...
How did the court explain the nature of the right to appeal to the defendant, or even confirm that the defendant understood either the oral or the written waiver?
So the judge did explain that the appeal waiver included the waiver of any argument that any error took place in these proceedings. Additionally, the judge did acknowledge that he saw the defendant review and sign the waiver with his attorney in open court, and that written waiver explicitly acknowledged that the attorney...
Sir, pursuant to your all plea agreement, in addition to giving up your right to a trial, you are making a separate and distinct agreement to give up your separate and distinct right to appeal. By giving up your right to appeal, you're giving up your right to argue that any error took place in these proceedings, or your sentence is too long, no matter how long it turns out to be. Do you understand? The defendant says yes. How is that adequate?
So it's our position that the statement, any error took place in these proceedings, is explicitly acknowledging that the defendant is waiving that right to appeal, the right to raise any of the issues from the sentencing proceeding, the plea proceeding.
Where do you see that? Is there any distinction or statement or explanation as to the appellate process or the rights which survive the waiver of the right to appeal, or what can be appealed or what cannot be appealed?
The rights that survive the waiver of appeal were explicitly listed in the written waiver, which the defendant signed.
Counsel, what about the colloquy? I mean, any is any, right? Your right to argue that any error took place in these proceedings. Are we supposed to imagine what any error means, or is it not definitive?
Your Honor, it's not definitive because we have that written waiver that lists those other
So
issues.
you're saying that if there's a written waiver, the colloquy doesn't really matter?
No, it's this court's precedent that imprecisions or overbroad language in an oral colloquy can be cured by a written waiver.
Supplemented.
Exactly, they can be supplemented with the written waiver, and here the written...
If you have 0 and you add a written waiver, do you end up with 1 or 2?
No, what is required if there is a written waiver is some on-the-record acknowledgement of the waiver of the right to appeal. We have that here, but in any event, even if this court were to reach the merits of defendant's claim, it is meritless. The unredacted search warrant, as well as...
Where did the court even ask the defendant if he had reviewed the waiver with counsel.
Well, the court did not ask him. However, the court did.
So isn't that another problem?
It's a problem per se, but the court explicitly acknowledged that the defendant had reviewed and signed the waiver in open court with his attorney, and the waiver acknowledged that the defendant had discussed the waiver of appeal with his attorney.
Quickly, what are the, going to the merits, assuming that the waiver was invalid, assuming that, what do you say to the arguments that the search warrant should have controverted?
The unredacted search warrant, as well as the testimony of the confidential informant, together establish the time periods of these controlled buys, and as Justice Clout acknowledged below, it was immediately after, and for those reasons, the search warrant was valid. If there are no further questions, we ask that you affirm.
Thank you. Yes, you have 1 minute.
Just to briefly respond to my adversary about the waiver of appeal, I would also reiterate that the waiver was not valid in this case and rely on the arguments set forth in my brief.
Thank you. Thank you both. Asian versus Flintlock Construction Services, LLC.
Good afternoon. Courtney Scharf of Wood, Smith, Henning, and Berman on behalf of defendant, third-party plaintiff, appellant. It's defendant's position that the lower court erred in finding a statutory violation of a Labor Law 240 subsection 1 as the scaffold used by plaintiff was an adequate safety device. The motion court found that the scaffold was too short and thereby was inadequate. However, it's defendant's position that in doing so, the court overlooked evidence that plaintiff was working on that very same scaffold for 3 hours prior to his accident occurring with the scaffold at the same height. Plaintiff.
So, counsel, why was the plaintiff on a wall?
So there was a scaffold.
Wasn't he directed by his supervisor to do the work on the wall? And did not his supervisor decline to raise the scaffold because they were behind schedule?
So that testimony is contradictory. At first,
I'm sorry, it's not what?
Plaintiff's testimony in that regard is contradictory. At first,
I'm sorry, I'm still not.
Contradictory.
Contradictory. Who rebutted it?
Plaintiff himself rebutted it. At first, he testified that his supervisor directed him to stand on top of the wall when he asked to raise the scaffold. And
Okay,
thereafter,
let's cut to the chase. He's standing on top of the wall, jackhammering the bricks, right?
Correct.
That's clear.
Correct.
Regardless of how he got there, what he did, the facts are undisputed that he's standing on the wall, jackhammering the bricks, and then he falls.
Correct.
Why isn't that 240?
Because the defendants provided plaintiff with an adequate scaffold. It
Well,
was
if
of
he
irrelevant-
fell off the wall, then that's kind of prima facie that wasn't adequate.
It's defendant's position that plaintiff climbed onto the wall on his own regard, that his supervisor did not.
But that is comparative fault. That has nothing to do with 240, right?
Was that?
It's comparative fault. 240 doesn't allow for comparative fault.
Well, it's defendant's position that because the scaffold was adequate, that there was no.
But he's told to chip to use the jackhammer or whatever in order to do whatever to the wall. And so his instruction is to perform those duties. So this is what he has to do. So as my colleague just stated, if he can't do so by being on the scaffolding and he goes up on the wall itself, that's comparative negative.
Right, so it's defendant's position that he could do so on the scaffold that he was provided. The scaffold was high enough and on an adequate level.
I think there was testimony that he was holding jackhammer up, and we know those things are heavy, and he's
Correct.
pounding away at the bricks, and after a while, you know, your shoulders are going to give way unless this guy's the Hulk or Hercules, right?
Right, so Exhibit C.
He is?
No.
Oh, okay. All right.
He is not.
He's not.
But so plaintiff relied on defendant's Exhibit C from plaintiff's deposition. However, plaintiff also
referring to the
testified that he
photograph?
was able to hold the
Counsel,
jackhammer at his.
are you referring to the photograph?
Yes, the photograph, Exhibit C of plaintiff's deposition.
So that photograph shows that the wall, let's see, the wall was in his words, approximately 3 to 4 feet above the scaffold. And in order to use that hammer, the arms of the plaintiff are fully stretched. So even assuming that scenario, what you're calling a safe scenario, had that vibrating jackhammer slipped, it would have gone straight into his chest. How are you possibly calling the scaffold a safe and adequate device?
Because I would respectfully refer the court to Exhibit B of plaintiff's deposition, which is at the record at 11:32, also depicts the way plaintiff was using the jackhammer at the time of the
So
accident.
this jackhammer, according to the plaintiff, weighed between 70 and 100 pounds.
Correct.
Okay? And the plaintiff testified that at some point in time, he asked Jimmy, who I guess was the supervisor, he asked Jimmy to move the scaffold up to level with the wall. And apparently Jimmy said, no, you just have to break it, just do it. And Jimmy also apparently stated there was no time to disassemble the scaffold. So again, the plaintiff is stating that the scaffolding was not appropriate for what he had to do. So how is this not a 240?
Because it's our position it was appropriate. If the court
Even if Jimmy tells him, even if he asks Jimmy to move the scaffold up and Jimmy says no, there's no time to disassemble it, it's still okay?
plaintiff had been working on that scaffold for days doing the exact
It doesn't matter. The bottom line is that he indicated it was difficult for him to, use the apparatus, and he didn't have sufficient arm strength. So if you don't have sufficient arm strength, if you find it difficult, and also if you are saying that you have issues with the safety conditions, please explain to me, how is that adequate?
You can think about that and respond on rebuttal. Thank you.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent. We obviously think the trial court got this one exactly right. I did want to point out one fact which isn't in the brief. You decided a case actually yesterday, directly on point.
Please tell me I wasn't on that panel.
I don't remember.
I don't remember.
Okay, it's the Silva against Toll GC LLC. Site is 2024 New York Ave, Lexus 919. And this is what you said. Plaintiff's foreman refused plaintiff's request to use a hoist to transport the staircase mold. I did give my adversary a copy of the case, so I want you to know.
Who was on that?
Yeah.
Judge Gonzalez? I wasn't on that, was I?
I'm still recovering from Barzdatic.
Right.
I have here
decision.
Weber, Gesmer, Gonzalez,
I
Pittsburgh.
thought it sounded,
Barzdatic, yeah.
Sorry,
yeah, I thought it was me.
not strict,
But
but
Mr. Isaac, at bottom, regardless of who said what, where, when, even if there's disputed issues of fact as to what instructions he got, the fact of the matter, I don't think there's any dispute that he's standing on the wall and he's pounding away at the bricks with a jackhammer and he falls off the wall, right? That's it.
That's it.
Doesn't matter how he got there, who said what, where, when, he fell off a wall jackhammering the bricks.
Judge Owen,
Plain and simple.
you're 100% right.
And there's nothing here that even suggests that he's a recalcitrant worker, right? They gave him a helmet, they gave him all the bells and whistles.
Well, they're not even,
He had to do his job.
And he
so
had
they
to
didn't even
forced
plead
to
that
do
as a
that.
defense, right? They didn't.
It's not a defense. I will sit down. Thanks.
There you go. Made your work easy for you today.
Good afternoon, Your Honors. Kevin Pollack from Fabiani, Cohen and Hall on behalf of the third-party defendant, respondent, employer. It is submitted that the court below's decision denying Flintlock's summary judgment motion on contractual indemnity should be affirmed. It's undisputed, and it's certainly not contested in Flintlock's brief that Sky Materials' primary insurer has provided additional insured coverage to Flintlock for this accident, and therefore their contractual indemnity claim is barred by anti-subrogation. There's nothing in their brief that disputes that, and since there's no dispute that they are being provided coverage, their motion for contractual indemnity should have been denied on anti-subrogation grounds.
Yeah, the plaintiff worked for Sky Materials, is that it?
Yes,
Okay.
and its insurer is providing additional insured and coverage to them.
You're an additional, right?
Additional insured.
Thank you.
Thank you.
Defendant,
Counsel, I just wanted to, I just wanted to correct something that was said. You did plead, or did say that the plaintiff was a recalcitrant worker, didn't you not? Recalcitrant worker?
in the underlying brief.
In the underlying brief, I thought so.
With regard to the anti-subrogation for the primary,
I think we were at the point where you were going to answer my question.
Defendants would rest on the brief in that respect.
Oh, no, I asked you a question about how could this be adequate when, the plaintiff had indicated that he was straining, he found it difficult because of the limited arm strength and the unsafe conditions, and you were going to address that, so.
Right, so again, I would respectfully request that the court look at Defendant's Exhibit B from the deposition where he was holding the jackhammer. He testified that he was working in that manner as depicted in Defendant's Exhibit B with the jackhammer at his waist, able to apply pressure to the bricks in front of him as requested. So it's defendant's position he was able to complete that work for the days preceding the accident, the hours preceding the accident.
How is that helping
all
you,
with the
counsel,
scaffold at that level.
when the photograph that I looked at shows him shows the wall higher than him and with his hands outstretched?
Right, that would be Exhibit C.
So how does Exhibit B eliminate Exhibit C?
Because it shows that plaintiff was able to not hold his arms above his head with the jackhammer.
At what part of the work? Perhaps that
That
work was completed?
What was that?
Perhaps that portion of the work was completed and then he did something else?
No, I mean, plaintiff testified that that photograph with the jackhammer at his waist had been taken the day before the accident or the day preceding that. So it shows that he was working in this manner for days, and simply that he became uncomfortable after working and asked his supervisor to raise the scaffold at that point.
Thank you all.
Thank you.
Lehman Brothers v. AG Financial.
Afternoon, Your Honor. Andrew Rossman for Lehman Brothers International Europe, or Libby as we call it. Libby bought protection from AGFP against losses on $5.7 billion.
Okay, so I have a question. Of
course, sir.
We all read what's going on here. You have here a dispute in terms of both sides get to calculate, in a sense, under this agreement, what they're owed, right, because of the early termination as a result of Lehman Brothers'
Yes, Your Honor.
bankruptcy, correct? So each side under the agreement gets to put in their amount, their numbers, correct? And it's the payment measure that I understood that was chosen was the
Market quotation method.
market quotation method,
Correct.
right? How did we go from the market quotation method to the loss
Great
payment
question.
measure?
In the contract, it provides that if the market quotation method fails, which happened in 95% of cases during the financial crisis, so very common, then you revert to the loss method. The cross-check principle, which is Hornbook law, recognized in ISDA cases, says the two should be roughly the same. That the loss method should mimic what it means to get a market quotation, meaning a market price, and that's what's fundamentally wrong.
So there's no dispute here. You're not disputing that applying the loss analysis, the loss, quote-unquote loss as the payment measure is okay. You're not disputing that.
Correct. The loss method applies. What we're disputing is whether it was objectively reasonable.
Right.
The loss method says, and it's important, right in the definition, loss or gain. It's a two-way payment or no-fault contract. So you value the
So you're
contract.
disputing what was presented as to whether the market computation was, whether the loss method was reasonable.
Correct, Your Honor. And the court's obligation here is to police that by determining whether it was objectively reasonable. And we submit the only way you can do that is by looking at prevailing industry practice and contemporaneous market prices.
So what did Judge Crane look at? Because her decision was, I think, 30-something pages.
Correct.
She went through the analysis. So what do you take issue with in terms of her
What I
analysis?
take issue is right on page 1 of her analysis. Justice Crane acknowledged that the standard is objective reasonableness, and then she spent 35 pages after that justifying what was an admittedly subjective analysis, right? So AGFP, who had a bias because all they did was sell this protection, so they had a financial incentive to minimize the losses. They had their own subjective view of what the losses should be that was completely different than the rest of the market. Lehman Brothers had hundreds of contracts, same exact trades.
How does a sentence, and I saw this in the briefs here, when the definition of loss under the agreement says, a party may but need not determine its loss by reference to quotations of relevant rates or prices from one or more, so it could be all of them, right? Leading dealers in the relevant markets. So how does that affect your position that, you know, everything has to do with market rates, marketability, market this, market that? What the court did below was it went away from the market analysis and did this other analysis, or accepted the defendant's analysis, right?
Right, so
How does that sentence affect your argument?
may but need not says that there's one particular bit of market data that you're allowed to use that's a safe harbor. You can use a dealer quote. They didn't, okay? It doesn't mean you could ignore all other market evidence. And this, Justice Friedman recognized for her retirement, she was a judge in this case, on summary judgment, in her opinion, she recognized that. And she said it would make no sense to hold as a matter of law if the market quotation process is unsuccessful, that Assured is free to adopt a methodology that results in a termination payment completely divergent from the cost of replacing the transactions. In other words, the question is, did what they do make commercial sense? Was it consistent with what other people did? Was it consistent with prevailing market prices? 043. It was completely upside down. The idea that in a financial crisis, that having the burden of paying protection on $5.7 billion of increasingly risky loans, that is a benefit to you, that AGFP was happy, okay, to have that burden. AGFP owed on its own books, 3 weeks before it terminated the trade, $438 million to Lehman. It disregarded that, came up with something that was never before used. No one in the case, in 5 weeks of trial, no one pointed to anyone doing this.
Does the agreement preclude them from doing that?
The agreement requires objective reasonableness and good faith.
That's not the question. The question is, does the agreement preclude them from doing what they did?
Well, the agreement, Your Honor, our submission here is that the agreement would ask New York courts to look at what they did and conclude it cannot meet that standard. It was subjective, they admitted subjective.
Look, whatever the case law is out there,
Yeah.
my training always takes me back to the agreement itself, the contract itself. Because believe it or not, the answers are in the contract, right? And if it's not there, it doesn't help one side or the other.
The contract says its loss or its gain, okay?
Right.
Based on, and it's got to be reasonable, and it's got to be good faith, and it says in the first instance, you look at market quotation. If there's not market quotation, it should be loss. The case law tells you those should be the same. That, Your Honor.
And we're in agreement that loss was the proper methodology here. You know, in terms of good faith is a very factual determination, right? I mean, that's up to the court looking at credibility, making sure that, I mean, good faith is just sort of really a...
But there's no intent when it comes to objective reasonableness, right? So we would submit, Your Honor, here's the case that we have before you. We have a case where it was a never-before-used methodology. Not one party in the marketplace had a value that agreed with their value. $500 million off, varied from their own books.
But counsel, I read your arguments. My only question is, everything they've done is something unique. This has never been done before. But does the agreement say you can't do that?
I believe it does. I believe the agreement does mean
Where does it say, can you point me to it? Because I read this agreement back and forth.
Of course.
And Judge Crane specifically stated that they followed the terms of the contract, considered all relevant circumstances, and therefore carried its burden to demonstrate that its valuation was commercially reasonable and in good faith.
Well, Your Honor, the problem with that, with Justice Crane's opinion, is she took their subjective point of view, admittedly subjective by their own witness, admittedly different than the rest of the market.
I don't think she referred to it as being subjective rather than based upon the conditions at the time of the valuation. But you do have time on rebuttal.
Thank you, Your Honor.
May it please the court, good afternoon, Your Honors. My name is Roger Cooper from Cleary Gottlieb on behalf of the defendant, Appellate Assured Guarantee Financial Products. I'll refer to it as Assured, if that's okay, and also Libby as the plaintiff here. This court should affirm...
So look, the starting point for me, I guess, is that we're all starting from the loss the payment measure as the loss method, right? Right, that's the starting point. Nobody's disagreeing that that was the method to use, right?
That's correct, right. There was an auction that was held under market quotation, it failed, and then we followed the loss, no dispute.
However we get there, we get there. The question that now is, he's saying that you've used some sort of a unique, never before used methodology in figuring out your loss. And my question is that we're in the agreement that says you can't do what you did, right?
Right, Your Honor. First of all, it wasn't unique in the way that Mr. Russman says.
That's what they're saying.
And was it subjective?
No, it was not either, Your Honor. Let me just explain. So what Assured used was a standard, well-regarded, well-accepted discounted cash flow model. Lehman's own experts had used such models in other cases.
In the Devonshire case, right?
Devonshire case, Your Honor, that was one of the cases, but also Nicolescu, one of their other experts, used it in the Solstice case. The court actually instructed the experts to use that method in that case. And this contract, the loss provision allows Assured to do that because as the non-defaulting party, it had the discretion to select the method of calculating its loss, and it expressly said you could calculate it based on loss of bargain. And Assured looked at what its bargain was here. It was a cash flow-based bargain. It was only obligated to make payments on the underlying insured securities if there were actual shortfalls in interest and principal. Yes, Your Honor.
Wasn't their methodology, it's what they do as a monoline insurer, correct? The same MO pretty much.
So the bargain that was struck here was the way it was because Assured is a monoline insurer. It's not asking for some special treatment because it's a monoline, but that's why it was bespoke in the way it was. So it did not have collateral posting, which standard agreements would have. It was pay-as-you-go, as I said, so that meant that you only actually made payments when there were shortfalls on the underlying, when they actually occurred. And in 26 of these CDS, you wouldn't make any principal payments if there were shortfalls until maturity, so not even until the end of the contract, okay? But there's ample law that says that this was an appropriate way to interpret loss.
Their position is that the court should have used it. Didn't go through the traditional looking at market analysis, right? And that's where they're, just hammering away at that. That's the wrong. Your analysis was totally wrong, and I just don't see somewhere in this agreement. I mean, that you're required to do that.
Correct, Your Honor. And let's recall, we were here before this court back in 2018 after Justice Friedman's summary judgment decision. Assured appealed the partial denial of summary judgment. And what Justice Friedman had said in that decision, she said that the loss provision gives Assured the discretion to make the determination as to whether the use of market prices to calculate loss is appropriate to a particular case. And what Lehman said was, well, look, we think it wasn't reasonable here because there's a uniform market practice of using market prices to calculate loss. And Justice Friedman said, okay, I think that gives you a trial. And this court agreed, have a trial. They had a trial. It was 5 weeks long. They had 14 trial days. They were given a rebuttal case. There were 11 witnesses total who testified. You've seen the thousands of pages of exhibits that the court reviewed, and there were hundreds of pages of post-trial briefing on all of these issues. And what Justice Crane said was, I heard all this evidence, you didn't come close to proving that there was a uniform practice that would have required use of market prices. It's the opposite. There was no consensus. The evidence showed no consensus on how to do that. And it comes from documents that their own experts relied on. It comes from testimony that, opinions that their own experts gave in other cases. Yes, Your Honor.
The only factor that had to be met was whether or not your amount was reasonable and was made in good faith. That's it. How you get there, it's okay, fine. However you get there, but there's only two criteria that you have to meet, right? The reasonableness standard and the good faith standard. If you hit both, doesn't matter if you went zigzag all the way, you hit both criteria, right?
Right. We don't think we zigzagged. I think that what we did was consistent with the agreement. It was consistent with the bargain.
I'm just making that as an observation.
That the party struck, but that's exactly right. You just need to, you have discretion. The non-defaulting party Assured here had discretion to select the method, and it only had to be reasonable and good faith. The argument that it was unreasonable was, oh, there's this other practice out there.
Yeah, how does that sentence that I highlighted affect all these arguments? A party may but need not, determine its loss by reference quotations and blah, you know what sentence I'm talking about in six, with the definition of a loss. How does it affect all this?
Right, it's the last line of the loss
Right.
definition, Your Honor. I think what it does is clarify this very point, and the key provision, the earlier sentences give the discretion to the non-defaulting party, and it says it has to be reasonable and good faith. But that last sentence says, for avoidance of doubt, a party calculating its loss may, but need not, use market prices or other market factors to calculate its loss. And so I think what it does, and Justice Crane said this, she said it's explicit that you may use those market prices, but the calculating party need not use them. And
So long as, again, it is reasonable and in good faith.
And that exactly, Your Honor. And the court had a trial on that reasonableness issue. And there were 4 separate grounds that she ruled on as to in rejecting the claim of Lehman. And it's not just that they failed to prove the.
So, counsel?
Yeah.
So this may be an ABC question, but your adversary, from what I'm understanding, says, look, so you had an auction and it failed, but you didn't have to go to the loss standard. You could have still used market quotation as your methodology. How come you didn't do that? And your answer is because so long as we were acting reasonably and in good faith, it was okay. Am I understanding that correctly?
Not quite, Your Honor. No, actually, under the agreement, when the market quotation method fails, you automatically go to loss. And so there's no question about staying with market quotation and following that process any longer. You go to loss, and then loss governs how it is that you go.
Your adversary, if I understand correctly, says that market quotation was not impossible, that it still was an avenue available to you, a methodology available to you. You simply chose not to use it.
That's not right. I don't think that's his argument. I don't think there's any dispute here that market quotation, that there was no market quotation available. The process requires you to get 3 bids. We held an auction and there were 0 bids. Not only that, they had a claim that they had brought originally against the auction and challenged the reasonableness of the auction, the appropriateness of it, and that was dismissed on summary judgment by Justice Friedman. And
We affirmed
no
it.
dispute.
We affirmed that the auction was kosher.
That is correct, and I welcome you to look at Justice Friedman's decision on that. And I just want to highlight, though, and I see the red light and I'll sit down, but Justice Crane looked at all the evidence and she said, I mean, not only do we not have to use market prices, but she said they weren't available. There were no market prices here on the evidence.
Because of the fluctuation of the market at the time.
Yes, correct.
Thank you.
Thank you very much, Your Honor.
Thank you, Your Honor. Just to respond to the last question, what our argument was that may but need not permits them to use a single market quotation even if you fail the market quotation method. They could have used market quotations if it went their way that valued this at $400 or $500 million. They chose not to because it conveniently was in their direction.
Well, counsel, at the end of the day, and that's why I asked early on when you began your arguments, that nobody is disputing that the loss method was the proper method
Correct.
to go, okay? And
Correct.
now the question is how that loss was calculated is what your issue is,
Correct,
right?
Your Honor. And if
they
the
use
loss-
some sort of unique,
It is.
never performed type of analysis, right?
There's no citation anywhere in the record of anyone ever using an insurance reserve methodology for valuing a CDS.
There's always a first time for
Methodology-
everything. There's always
You're-
a first time for everything.
But Your Honor, no one else did it in the marketplace at the time. It would completely disagree with all the other prices and, okay, and if I may, the insurance reserve methodology says on its face it's not to be used for derivative contracts and that it permits a subjective approach. Your Honor, in response to your earlier question about subjective or objective, their own witness, Mr. Rosenblum, admitted it was a subjective methodology, A1687 in the record from their own lawyers questioning, okay? And importantly, on the question of reasonableness, it cannot be reasonable for them to submit no evidence at all, utter failure proof, on 26 of 28 of these trades. Again, their own witness admitted, and this in response to Justice Crane's question, that he did not know. He did not know how this calculation was done for 26 of 28 of the trades. Utter failure of proof. That can't be reasonable if there's no calculation at all. And
Let me ask you this question.
yes, sir.
Let's say I agree with you. Where would this go then? Would this be a remand?
Very simple, Your Honor. There's two options here. You can either enter judgment for us as the only one who put in evidence.
$485 million?
Your Honor, it's $5.7 billion
I know,
losses.
okay.
But
Sorry, that was $1 billion off.
But, Your Honor, we have a fundamental error of law in applying a admittedly subjective valuation where the contract and the law in this case, okay, First Department's prior decision requires an objective standard. You certainly at a minimum should vacate and remand to ensure that the court actually applies an objective standard. We're the only ones who submitted industry evidence, the only ones who submitted market evidence. It all lines up with our case, Your Honor.
Thank you. Thank you
Thank you.
both. Hayes v. Anderson and Shepard. And the courtroom clears for $20 billion.
Good afternoon, Your Honors. May it please the court. Joshua Krakowski for the appellant, Anderson and Shepard Limited.
You must have said something. They all left.
You know, that happens to me a lot. So this is a forum nonconvenience case. We moved to dismiss a pretty sparse complaint from the respondent for a claim for an accounting. Now, the respondent is a resident of New York, but that's the only fact in this entire case that connects any of the facts in this case to New York whatsoever.
That's not the controlling factor, though, I don't think, right?
That's true. The Court of Appeals set out 7 different factors that need to be weighed in a forum nonconvenience analysis. And in our brief, we went through them and showed that of the 7 factors, 6.5 weigh in favor of dismissal based on forum nonconvenience. Factor 1 is the existence of an adequate alternative forum. I don't think anybody disputes that England is an adequate forum. They have due process there. Our own legal system is based in large part on the English common law. The residence of the parties is factor 2. One party lives in New York. My client is based in London. You know, they have they're a Severo tailor. They just have one shop in London. They travel. They come to New York once in a while to sell some suits, but that's it. They're an English company.
What law would apply?
We think English law would apply. You know, this is an English company formed under English law, so whatever the rules are in terms of whatever duties the corporation owes would have to be under English law. I don't see any basis for New York law to be applied here. And if it did, and this is in our brief too, something that was overlooked by the trial court, is that under New York law there is no claim for an accounting. Because there's no fiduciary duty.
To a shareholder.
Right. So the fiduciary duties are owned in a closely held corporation. There are fiduciary duties that are owed by the majority shareholder to the minority shareholder.
That brings up a case where I got reversed on for doing that, yeah.
I'm sorry to bring it up.
Okay.
This is a suit against the actual corporation.
So this is a suit against the corporation. The corporation has no duties. Had the respondent sued the managing shareholder, perhaps, you know, I wouldn't have this argument. I would be making different arguments. But there's no claim under New York law. So we say that's another basis for forum nonconvenience to be applied here because English law applies.
Well, London would have definitely more vested interest in this kind of resolution of this case because you're talking about a company that's, you know, incorporated and doing business out of London, right?
Correct. I mean, I think...
The plaintiff says that the fact that the defendant has fittings in New York, you say 2 times a year, he says 4 times a year. That plus the fact that suits are sold here in New York creates a sufficient nexus. What do you say about that? I know that the record indicates that the transactions ultimately occur in England, but where does this fall?
Right, so those facts go to personal jurisdiction. and whether or not there's general jurisdiction over Anderson and Shepard to defend cases in general in New York courts. Whether or not there's jurisdiction over Anderson and Shepard is completely irrelevant towards a forum nonconvenience analysis, and this court held explicitly that. So, I mean, that's one of the things I think that the plaintiff and the trial court got mistaken, is they conflated the two jurisdictional arguments and the forum nonconvenience arguments. And the lower court found, and we're not appealing, that there was enough allegations here to support personal jurisdiction. So that's not before this court at all. And then I see my time is almost out, so I just wanted to mention one other thing, is that we think that the complaint should be dismissed without prejudice if all of our other arguments fail, because the plaintiff did not file a complaint within 20 days after getting a demand for a complaint. And I'll reserve my time. Thank you, Your Honors.
Thank you.
First of all, I apologize for not wearing a tie. I have very bad arthritis in my hands and I can't tie a knot, right?
Okay, you could have worn a bow tie. You could have done a pin-on,
Judge,
a clip-on bow tie. I'm sure you have it in your wardrobe.
I don't have any clip-on bow ties.
No? Okay, sorry. Go ahead.
I'm wearing Anderson and Shepard suits. I can't wear it, eh?
Oh, okay.
I own 16% of the company. I got my share inherited from a guy that was a long-term managing director. She got the ownership from her father, Tiny Rowland, who's very Googleable. She inherited it. My point is, I own a minority interest. They don't pay sales taxes in New York. That gives a very strong connection to New York.
But all the issue, one of the issues that was brought up is that the books and records are in the United Kingdom. The English law would probably apply.
I don't think so. I think that.
Well, you would not have a basis for an accounting here in the United States, right?
Yes, I would.
Why?
Because I'm a minority shareholder. Somebody comes in and says, you didn't pay taxes here forever, right? Then who's going to pay those back taxes? Is the business going to pay? Which means I'm going to get wiped out. My equity's going to
So the violation of the fiduciary duty is because no taxes are you're not being levied taxes, and therefore you would be evading some type of taxes here in the United States?
Oh, well, it's not, I don't, I'm not evading taxes. I'm saying that the company will owe a lot of money in back taxes. And if they pay it as a company rather than her as an individual, that my shares are going to be worth nothing.
But you're suing the company, you're not suing an individual.
Well, I'm not at this point.
Well, what is before us is a suit before the company, not a lawsuit
Well,
against
that's
an
because
individual.
I only want an accounting from the company. If the issue of whether or not I go back and sue her personally and say she should be paying this rather than the company is a different issue. Oh, by the way, they're very famous. The King of England is their customer.
So again, in response to your adversary's arguments concerning English law, concerning the books and records, what do you have?
Well, first of all, the books and records is easy. That's a thumb drive. So that's easy. All I need is an accountant in England, right? One. Two, as far as English law, I'm a New York citizen. I'm entitled to an accountant. That's it. Right? That's the law in New York. You're entitled to an accounting. I'm a stockholder. I own 16%. I want an accounting because I don't know what she's doing. Apparently, she doesn't pay taxes anywhere in America. She's going to get caught, right? And when she gets caught, I'm going to get wiped out. I don't think that's right.
I'm just curious, what, if any, excuse did you provide, because your adversary brought it up, that you filed the complaint 4 months after the 20-day demand?
What about that? I've had a lot of health problems over the last period of time, and that was the reason. I had COVID 3 times. I had pneumonia once. I had a concussion. If something could go wrong with your body, I got it.
Well, we're glad you're okay now.
So am I. I have the after effects of the concussions. Thank God I have a healthy, strong son.
Glad to see you now. That's
Thank you
the
very
main
much,
thing.
John.
Thank you.
Thank you very much.
So why would he not, I mean, in terms of his being wiped out, why therefore would he not be entitled to an accounting?
I'm not saying he's not, just not here in New York. You know, this is an English company, subject to English law. All the documents are located in England. You know, my adversary says, oh, it's just a thumb drive, but isn't that true for every case? You know, I mean, this court was remote for a long time, and I did an argument in this court remotely. It's not as nice as being in person, you know. When you have depositions, I like to be in person. I don't want to be forced, you know, on a motion to dismiss by a trial judge to say, oh, you could take a deposition by Zoom.
To some extent, it is discretionary by the court.
Sure.
Is it not? And he is
Absolutely.
a citizen of the United States and a resident of New York, and he is requesting an accounting. So again, why would it be a breach of discretion or violation of the court's discretion to allow it to proceed?
Well, first of all, yes, the trial court certainly has discretion, but so does this court. And the appellate standard is not abuse of discretion. This court needs to exercise its discretion independently on a forum nonconvenience analysis. And I think given the facts here, you know, overwhelmingly it is in favor of dismissal based on forum nonconvenience. And just one point that my adversary said, that my client doesn't pay sales taxes in New York. I mean, that just shows that this company has no connection to New York. I think it cuts against him. You know, and I think one last point is that, you know, it's hard to not have empathy for my adversary, you know, which I think the trial judge had and you know, could have resulted in the way the decision worked out. But the law is the law. Forum nonconvenience is a valid theory that should result in dismissal of this case, and the plaintiff should, if he wants to pursue this, he's free to go to a London court. Thank you, Your Honors.
Thank
No
you.
further
Thank you
questions.
both.